Your Honor, we're still waiting on one raider. We're going to move one over from a different courtroom who had one extra. So it just might take 1 second. I'm Emily, the courtroom manager for today. And while we wait for that other raider, I just want to confirm with the teams that everyone is present.
Yeah, that's fine.
Okay, great. Team WS, is everybody here and present?
Yes.
Great, thank you so much. And Team PS, is everybody here and present?
Yes, everyone's present.
Thank you so much. Okay, Your Honor, we will get that other raider in as soon as we can.
All right, thank you.
Of course. Your Honor, we just got our third raider into our courtroom. And Raider J, if you refresh your page in process, you will be assigned to this courtroom now. So you should have the updated ballot.
Great, thank you.
Of course.
So we are ready to go?
That's correct, Your Honor.
All right, good morning. This is State v. Whitney. If I can get the attorneys to make their appearances for the record, please. State your name for the record, please.
Hello, my name is Denali Rojas, and today I will be representing the state.
My name is Frida Gallegos Maravilla, and I am also representing the state.
And my name is Alas, and I will be representing the state as well.
And for the defense?
Good morning, Your Honor, members of the jury and opposing counsel. My name is Peyton Nichols, and I, along with my co-counsel, represent the defendant, Tracy Whitney.
Good morning. My name is Jessica McDowell.
Good morning. My name is Maya Miller. And Mayor, witnesses introduce themselves in order of appearance.
Yes.
Good morning. My name is Dario Kavaba Wood, but today I will be playing Tracy Whitney.
Good morning, Your Honor. My name is Sam McGee, but today I will be playing Robin Hess.
Good morning. My name is Margaret Collins, but today I will be playing Aylin Strong.
Good morning. My name is Sawyer Schultz, but today I will be playing Britt Smithson.
All right, does that cover everybody?
May the state introduce their witnesses in the order of appearance?
Yes.
Thank you.
My name is Faith Travis, and today I will be playing Dell Hubbard.
My name is Amara Berry, and today I will be playing Meryl Grimm.
My name is Aidan Ringel, but today I will be portraying Wesley Everett.
My name is Joanna Pena, but today I will be Detective Jaden Brandenburg.
All right, is that everyone? All right, are there any pretrial motions?
Your Honor, before we get into our pretrial motion, we just have one preliminary matter to address.
You may go forward.
Now, regarding exhibits, we will lay foundation for the admission of exhibits during testimony. When we use Zoom's screen share function, the jury will see exhibits before they have been admitted. By stipulation, all exhibits are authentic and will be admitted into evidence. We simply ask that the jury be instructed to not consider any exhibits until they have been admitted.
All right, jury is so instructed.
And that is all from the defense, Your Honor.
All right. Either side have any pretrial motions?
We would also like to present some preliminary motions on behalf of the state.
You may-
And we
you may
ask that
proceed.
time be stopped for the duration of lengthy objections and impeachment, for the exhibits to be constructively outside of the jury's view unless published, and for the opportunity to have a 5-minute recess after this prosecution rests their case.
Your Honor, I have one objection to that. We ask that time not be stopped for impeachments.
So I'm not sure if that's typically done, but I mean, impeachment should be, it's part of your examination, so it should be included in the time.
And Your Honor, or excuse me, opposing counsel, what was that second preliminary matter you mentioned regarding exhibits?
Yes, for exhibits to be constructively outside of the jury's view unless published.
Right, which I understood to be the same as the previous motion.
Yes, Your Honor.
Yes.
That's fine. And if typically people are taking 5-minute recesses between, that's fine with me if that's what's typically being done. All right. Are there substantive pretrial motions from either side?
Yes, Your Honor. The defense brings a motion in limine.
Okay, you may proceed.
Your Honor, today the defense seeks to exclude all statements allegedly made by Britt Smithson during a video conference on August 22nd, 2019. These statements should be excluded as hearsay under evidence rules 801 and 802. Specifically, none of these statements are admissible under 801D2. They are not adoptive admissions. They are not co-conspirator statements. Now, on August 22nd, 2019, the defendant, Mr. Tracy Whitney, held a video conference. This conference was with members of his organization, Debunking Mysteries, or DMIT. Whitney wanted to debrief a protest in the Barryton chapter of DMIT in Pine County, Washington. However, the head of this local chapter, Britt Smithson, brought up the topic of an Australian protest affiliated with the DMIT organization. Smithson used this protest as an opportunity to give a speech that is now the statement at issue. Now, the prosecution may claim that these statements are an adoptive admission. However, with this rule, we must also take into consideration the difference between deflection and acquiescence. While to deflect means to turn aside or deviate from course, to acquiesce means to comply passively, to accept as indisputable or inevitable. How does this relate to our case? State v. Hill offers a perspective. In Hill, the appellate court held that the trial court erred in admitting a number of statements, as there weren't sufficient foundational facts to show that the defendant acquiesced. While he did reply to the statements, he did not accede to the assertions. Likewise, there aren't sufficient foundational facts in this case to show that Whitney acquiesced or acceded to what Smithson said. While he did respond to the statements, he did not accede to the assertions. On the contrary, testimony from the prosecution's own witness, Wesley Everett, supports our contention of Mr. Whitney's deflection. Wesley will testify that following Smithson's statements, Whitney thanked Smithson and moved the meeting along to a budget item. Whitney himself will testify that he was only half listening to Smithson's speech as he had another meeting to get to in 15 minutes. Nowhere does anyone say that Mr. Whitney acquiesced to what Smithson said. He brushed the statements aside. He deflected them. Your Honor, these statements are further inadmissible under the co-conspirators rule. Now, unlike an adoptive admission, the prosecution must prove by a preponderance that a conspiracy existed. State v. Anderson held that the trial court must find the existence of a conspiracy before admitting any statements. At this point in our case, there is not enough evidence and there are not enough facts to show that Britt Smithson at any point became a member of a conspiracy. These are facts that the prosecution must provide but won't be able to. Further, accepting the state's arguments means accepting that a conspiracy existed in the first place. This is exactly what we are here to decide today. By accepting these statements, the prosecution would be bootstrapping. It's for these reasons, Your Honor, that Mr. Smithson's statements are inadmissible, and the defense asks that you exclude these statements as hearsay under evidence rules 801 and 802. Thank you.
All right, hear from the state.
Yes, Your Honor, thank you. The state requests the court to deny the defense's motion and allow the jury to hear evidence of the statements made by Britt Smithson. These statements were made while with the defendant, witness Wesley Everett, and others on the day of August 22nd while in an organizational meeting for the Debunking Mystery organization. The purpose of the meeting was to promote the removal of the statue from the town square, and Britt Smithson actively promoted violence. And after this meeting, the statue in Barryton was damaged and a city employee was injured. These statements are admissible under two prongs of ER 801D2. ER 801D2E provides for admissibility of a statement made by a co-conspirator. In order to be admissible, the state must prove three things: that a conspiracy exists, that the defendant was part of said conspiracy, and that the statements in question were in furtherance of the conspiracy. These elements are met here. The first two elements are intertwined. The state can provide at least three pieces of independent evidence showing the existence of a conspiracy to illegally remove the statue and the defendant was part of that conspiracy. This includes emails and text messages from the defendant, a threatening letter sent by the defendant to Mayor Grimm of Barryton, and evidence of coded language calling for violence, including expert testimony by Detective Jaden Brandberg. The independent evidence tends to establish the existence of the conspiracy and the defendant's direct participation. As the court explained in State v. Anderson, the quantum of the independent evidence need only be slight. The question is whether, in the opinion of the trial courts, the independent evidence tends to establish the fact of a conspiracy. We have more than met that burden here, and the first two prongs of the test are met. For the third prong, the statements were during and in furtherance of the conspiracy. In both State v. Israel and State v. Baruso, in furtherance is broadly defined and can include statements meant to induce further participation or to inform a co-conspirator about the status of conspiracy. Here, the statements occurred before the final protest on September 16th. The defendant and numerous other members of the organization were present, and the statements by Britt Smithson were clearly efforts to enlist the other group members to get on board with the idea of violent action to take down the statue. Thus, this is an ongoing conspiracy, and the third prong in the test for admissibility is met. Therefore, these statements should be admitted under ER 801D2E. The statements are also admissible under ER 801D2B. That rule provides that statements of which a party has manifested an adoption or belief in its truth should be allowed into evidence. These are called adoptive admissions. State v. Nesland and State v. McCahey note that adoptive admissions are allowed when the defendant heard or was presented with an accusatory or incriminating statement and neither denied, contradicted, or objected to it. That is exactly what occurred in this case. Britt Smithson made suggestions and incitements of violence and illegal action. The defendant responded by saying, "Thank you, Britt, very interesting." Thus, the defendant was presented with incriminating statements calling for illegal action and the use of force against city workers and did not deny, contradict, or object to them. Therefore, similar to the incriminating statements in State v. McCahey, the defendant's positive reaction to Smithson's statements constituted an adoptive admission. The statements
do you think that the statement saying "thank you, very interesting" is adopting that is showing an approval of that statement?
Yes, Your Honor. The defendant could have easily said, "I don't agree with what you are saying," but instead chose to say that it was very interesting.
Well, right, but I guess my question is, does very interesting mean I agree? I mean, can you not have things that you think are interesting but that you disagree with?
I believe it does mean that she was in favor of what Britt Smithson was saying.
Proceed.
Thank you. So therefore, similar to the incriminating statements in State v. McCahey, the defendant's positive reaction to Smithson's statements constituted an adoptive admission. The statements should be admitted under ER 801D2. For these reasons, we ask the court to deny the defense's motion and allow the statements to be admitted into evidence.
Okay, rebuttal?
Yes, Your Honor. I'd first like to answer your question regarding the characterization of Whitney's statement, "Thank you, very interesting." Now, the statement is best characterized as a deflection, as there's no acceptance of Smithson's statements being shown in this phrase. "Thank you, very interesting" is something Whitney said to deflect and brush aside Smithson's statements and move the meeting along. Now, counsel referenced State v. Nesland, but this case doesn't apply for a few reasons. First, this case is clear that silence itself doesn't constitute an admission. In our case, the reason for Whitney's supposed silence isn't clear. And the prosecution's own witness, Wesley Everett, supports a factual argument that we can't assume that Whitney was silent. Second, nothing in Everett's report of the video conference supports that Whitney said anything accusatory. Even if Whitney did make an ambiguous statement like very interesting, this would be best characterized again as a deflection.
So address the co-conspirator element of the admission.
Yes, Your Honor. The state may be able to provide whether or not the existence of a conspiracy did occur on a number of bases or prongs, but they're not able to before the beginning of this trial. As mentioned in State v. Anderson, the prosecution must prove by a preponderance that co-conspirator statements were made before the start of this trial, which they will not be able to do, as there is not enough evidence to support this finding as of yet.
Thank you. Anything else from you?
No, Your Honor. The defense again asks that you exclude these statements as hearsay under evidence rules 801 and 802.
All right. Sir, rebuttal?
Yes, Your Honor. Now, opposing counsel finds that Tracy Whitney's response to Smith's statement was a deflection, but that's profoundly not the case. The defendant was the head of the organization and of the meeting, a meeting which discussing the next steps for debunking mystery and the movement to remove the statue. Smithson suggested that they knock down the statue and shove any employees out of the way, and the leader of this peaceful organization responded by thanking Smithson for his comments and stating that they were very interesting. This, Your Honor, is not a deflection. It is a positive reaction that did not deny, contradict, or object to them. It is a statement of support and such admissible under ER 801 D2B.
All right. Anything else from you on the co-conspirator issue?
No, Your Honor.
All right. The court is going to deny the defense motion to exclude. The statements of Smithson are admissible. Are we ready to proceed with with opening statements? Here are the opening statements from the state.
Yes, Your Honor. May it please the court. The test master is the defendant, Tracy Whitney. The pawn was Wesley Everett. The defendant's goal is to remove every historic statue by any means necessary. In the summer of 2019, Fraser set his sights on the Alton Berry statue in Barrington, Washington. My name is Cadell Velasquez, along with my co-counsel, represent the state of Washington. This case is about the defendant's plan and actions to remove the Alton Berry.
I believe he may have been disconnected from the call or something of the sort. He appeared to be having Wi-Fi issues. I think we could.
Looks like he's back. Yeah, he was breaking up in the 30 seconds or so before he cut out. So I don't know if others were having problems hearing him. I was not able to hear what he was saying.
He was for me as well.
Your Honor, we are working on resituating and getting that issue solved.
All right, thank you.
Thank you.
All right, I believe I have connection again.
All right. You may want to start over because I think there was trouble hearing you even before you cut out. So you might want to just start from the beginning.
Okay. May it please the court, counsel, members of the jury. The chess master is the defendant, Tracy Whitney. The pawn was Wesley Everett. Tracy Whitney's goal was to remove every historical statue by any means necessary. In the summer of 2019, Tracy set his sights on the Alton Berry statue in Barrington, Washington. My name is Cadell Velasquez, and along with my co-counsel, Denali Rojas and Frida Gallegos Maravilla, we represent the state of Washington. This case is about the defendant's plan and actions to remove the Alton Berry statue. He developed a plot using code words, encrypted communications, and his pawn, Wesley Everett. His carefully planned scheme ended with a violent protest on September 16th, 2019. At this protest, Wesley Everett violently attacked and damaged a statue, as well as seriously injured a city worker named Dale Hubbard. Wesley Everett has accepted responsibility for his role in the attack. We are here today because the state has also filed criminal charges against the defendant as the mastermind behind the illegal plot. The defendant is charged with malicious mischief first degree, assault second degree, and criminal conspiracy. As the judge will instruct you at the end of this trial, under the law, Tracy Whitney can be held just as responsible for the devastating injuries to Dale Hubbard as the person who actually swung the hammer. How did this all start? Well, the defendant is the founder of a group called Debunking Myth Story, or DMITE for short. During this trial, you will hear about DMITE, its website, mission, and meetings. You will learn about coded language, encrypted communications, and exclusive video conferences. Through these methods, the defendant was able to orchestrate and direct the events of September 16th, 2019. And like a master chess player, she controlled her pawn, Wesley Everett, and moved him into a position to destroy the statue and win his game. Today, the state will present testimony from 4 witnesses. First, you will hear from Dale Hubbard, a groundskeeper for the city of Barrington. Ms. Hubbard will explain that she was present at 3 protests during the summer of 2019, including the September 16th protest. She will explain that the protesters were holding phones and other similar devices at the final protest, and that she could hear someone broadcasting over them. Finally, she will describe how she was seriously and permanently injured by Wesley Everett as he tried to stop the attack on the statue. Next, you will hear from the local mayor, Merrill Grimm. Ms. Grimm will testify about the effect DMITE had on Barrington, as well as the uncompromising behavior from the DMO organization. He will explain the threat they posed to the community, as well as the threatening letters he received from Tracy Whitney himself. Next, Wesley Everett will testify about Ms. Whitney's violent plans for the final protest. He will explain the inner workings of DMITE and how Tracy Whitney communicated with the group members through encrypted communications and coded messages. His testimony will show Ms. Whitney's direct call for violence to achieve DMITE's goals, including her use of the code word energetic tango, the code or the message for him to bring down the hammer at the final protest. Finally, you will hear from Detective Brandenburg, the lead investigating officer and an expert in deciphering coded language. She will explain DMITE's use of code words such as energetic tango to secretly communicate with the organization. She will testify to the many instances in which coded language was used by the defendant to call upon DMITE members for direct violent action. Members of the jury, after hearing all of the evidence, it will be clear that the defendant controlled the events of September 16th, 2019. Tracy Whitney set up all his pieces, used code words, encrypted communications, and was ready for checkmate. But he didn't count on Wesley Everett stepping forward to take responsibility and reveal the defendant's game plan. At the end of this case, we will ask that you hold the defendant accountable for his actions and return a guilty verdict on all 3 counts. Thank you.
Thank you. Hear the defense opening at this time?
Yes, Your Honor. A controversial statue and a peaceful protest against it. Now, as Mr. Pina told you, the prosecution will have you believe that on September 16th, there was a conspiracy and a plan to violently take down a statue in Barrington, Washington. Well, you'll learn that there was a plan, but it wasn't a violent one. There was a plan for legal action and the lawful removal of a statue. A plan that was thrown off the rails when one person went rogue. Because of his actions, a statue was damaged. An innocent groundskeeper was injured. Today, you'll learn that only one person is responsible for these crimes. A person by the name of Wesley Everett. Wesley Everett picked up a sledgehammer and used it to attack a statue. But even though he decided to do both of those things, my client, Tracy Whitney, is being charged with 3 crimes. Now, Mr. Pina just talked a lot about pawns and chess masters, but pay attention to how there was no game. There was only one player. You'll learn that my client is guilty of none of these crimes because it was a partnership of 1, Wesley Everett, and a conspiracy of 1, Wesley Everett. Let's break down those 3 charges. First, assault. The prosecution will try to tell you that Wesley Everett assaulted a groundskeeper for the city of Barryton. But members of the jury, one very important element to this crime is that there must be intent to cause physical harm. Wesley Everett himself will testify that he did not intend to hurt anyone. Everett is a prosecution witness, and he will contradict the prosecution's case. Keep in mind that if there's no intent, there's no assault. Second, malicious mischief. The prosecution will tell you that there was a partnership between my client and Wesley Everett to take down a statue. But you'll learn that the only partnership in today's case was a partnership of only one person. You'll hear about a series of 5 protests that were held by the DMIT organization. The first 3 were peaceful, but things started to change after that. The 4th protest led to a pushing and shouting match in the crowd. And the 5th protest, on September 16th, ended with Everett's attack on the statue. A. Lynn Strong, a reporter and writer in Barryton, will tell you that at these protests, Wesley Everett was the only person who acted violently, and that he acted alone. Now, Wesley Everett will try to tell you that he acted violently because some code phrase was yelled. He'll say that a whole group of people knew that this code phrase meant that it was time to use physical force. But members of the jury, ask yourselves, if everyone knew what this code phrase meant, then why was Wesley Everett the only person who acted violently? Members of the jury, you'll learn that Wesley Everett went rogue from his organization. It was a partnership of one person. Lastly, criminal conspiracy. You'll hear Wesley Everett testify that he conspired with my client to act violently. But you'll also learn that Wesley Everett has pled guilty to 3 crimes, and his sentencing for those crimes is still hanging in the balance. In fact, it depends on his testimony in today's trial. Now, Detective Brandberg will talk about her investigation, but pay attention to how she was unable to make any progress until Wesley Everett started talking in jail. Pay attention to how the investigation hinges on Wesley Everett. All of the emails and texts that you'll see are from specific dates chosen by Wesley Everett. Wesley Everett manipulated Detective Brandberg's investigation. You'll see that the prosecution's entire case depends on Wesley Everett. But members of the jury, you'll also learn that all of these communications are protected by the First Amendment. Professor Robin Hess will take the stand. As an expert in First Amendment law, he'll explain what exactly the First Amendment protects and what it doesn't. Listen for his expert opinion on whether or not my client's statements are protected by the First Amendment. Members of the jury, today's case is about a partnership of one and a conspiracy of one. And at the end of our trial today, my co-counsel, Mr. Nichols, will ask you to return a verdict of not guilty on all 3 charges. Thank you.
All right, state and call its first witness.
Yes, Your Honor. The state would like to call Adele Hubbard.
All right, I understand all the witnesses have been previously sworn.
Yes, Your Honor.
You may proceed.
Okay. Ms. Hubbard, can you see and hear me all right?
Yes, I can.
Okay. Please state your name and spell the last for the record.
My name is Del Hubbard. That's Hubbard.
And Ms. Hubbard, leading to September 16th, 2019, where were you employed?
I was the head groundskeeper for the little city of Barrington.
And why are you no longer employed by the city?
Well, on that day, I was severely injured during a protest and could no longer perform my job.
Okay. How were you injured?
I was at work where the protest was happening when one of the protesters hit me.
Okay. Is it okay if I talk to you a little more about what happened that day?
Sure.
Okay. Can you walk us through what you did on September 16th?
Well, my team and I went downtown to the plaza where the protest was happening to clean up the area.
And at the time, did you know what the protest was about?
Actually, I did. The protesters wanted the statue of Alton Berry to be removed.
Okay, so once you arrived at this protest, what did you do?
I just sat there and waited until I could start cleaning, which is pretty much what I'd done at the previous protest as well. I didn't want to get in their way.
So you were there for more than one protest?
I was. This protest was the 5th protest of the summer. My crew and I came in after the first 2 to clean up. There was a lot of garbage around it, but this more proactive approach seemed to help.
Okay, and what was the 5th protest like?
Well, it was very different from the previous protests I'd attended.
In what way?
For one, it was smaller, and I didn't recognize most people in attendance.
Okay, was there anything else?
Yes, the speeches were also more slurry. Almost everybody had a phone or tablet in their hand.
They were holding tablets?
They were listening to someone on these devices. I could actually hear them talking. Plus, they were also recording the main speakers.
Okay, and who were these main speakers?
Britt Smithson and Wesley Everett.
All right, were you able to notice any specific phrases?
Yes, they were shouting about a blockhouse or house of cards coming down. I also heard something about high energy and tango.
Okay, so you mentioned that you were injured at this protest. When did that happen?
It happened near the end when things were about to break up.
Okay, can you tell us what happened?
Well, I started walking towards my cleaning cart, which just a few feet away from the statue, when one of the speakers from before, Wesley Everett, jumped on the base of the statue and started hitting it.
Okay, hitting it with what?
With a sledgehammer.
And what happened after Everett jumped on the statue?
Well, everyone around started cheering and pumping their fists in the air.
And what was the other speaker, Smithson, doing when this happened?
From what I saw, he was actually the one who handed Everett the hammer.
Okay, and what did you do while this occurred?
I walked up to the statue and tried to shout at him to stop.
And what happened then?
Well, I looked down for a moment and I heard a loud clang, and that's when the statue's arm fell and hit me hard on the shoulder, breaking in multiple places.
Okay, and do you remember anything else?
Yes, I remember I was on the ground, and soon after I felt something hard hit me on top of the head.
Okay, did you ever find out what it was that hit you?
I did. I later found out it was the sledgehammer.
The sledgehammer that Everett was holding?
Yes, the sledgehammer that Everett was holding just a few seconds before. I saw he had a good grip on it.
Okay, and do you remember anything else about that day?
No. The next thing I knew, I was in Pines County General Hospital in a lot of pain, and I didn't even know the recovery I had ahead.
Thank you, Your Honor. No further questions.
Cross-examination?
Yes, Your Honor. Good afternoon, Ms. Hubbard. Now, I'd like to first ask you a few questions about that protest on September 16th. At the protest, quite a few people had some sort of device on them. Is that correct?
Yeah, phone or tablet.
You just said on direct examination that you could actually hear people talking. Is that right?
I could, yes.
Now you say you heard someone talking through these devices. Is that right?
Yeah, I heard several phrases, blockhouse, has cards, things like that.
Ms. Hubbard, you also testified that you didn't hear what they were saying.
I heard a few phrases.
Ms. Hubbard, you testified that you aren't even sure that someone was talking through these devices at all.
Well, I believe they were. I mean, I couldn't know for sure. There's a lot of noise, but I heard several. I heard what I needed to, basically.
In your own words, Ms. Hubbard, it could have even been feedback from this event. Is that right?
I guess so, but I feel like I heard several phrases. I'm pretty sure I heard somebody.
Okay, now, Ms. Hubbard, you filed a lawsuit against Wesley Everett. Is that correct?
Well, just trying to rebuild my life. I need a reason to get out of bed. So yes.
Is that a yes, Ms. Hubbard?
As I said, yes.
You filed a lawsuit against Britt Smithson.
Among other people, yes.
One of those other people was Tracy Whitney?
Yes, among others.
Ms. Hubbard, you filed a lawsuit against the entire Debunking Mystery organization.
Yes, I think I've made that clear.
This is a multi-million-dollar lawsuit?
Well, quite honestly, I believe I deserve that money for the damages. I don't even live my normal life, and so yes, I did.
All right, Ms. Hubbard, as part of this lawsuit, you're making a claim for punitive damages.
Yes, my life is destroyed, and I think I deserve a little bit of money for that to help me rebuild it.
Ms. Hubbard, this wouldn't just be money you deserve, it would also be your claim for punitive damages?
Yes, that's correct, as I said before.
Right, now we can agree that you didn't see Mr. Whitney at that protest. Is that right?
No, I don't really know what she looks like, so I don't think so.
Right, so you didn't see Mr. Whitney jump onto the statue?
As I've said before, I don't think so. Again, don't know what Whitney looks like. Sorry.
Hubbard, Mr. Whitney wasn't the one holding the sledgehammer, was he?
No, it was Wesley Everett.
That's right, and it was also Wesley Everett who jumped onto the statue.
As I said before, yes.
It was Wesley Everett who hit the statue with the sledgehammer 3 times.
I think it was 3 times. I have trouble with numbers now, sorry.
Okay, Ms. Hubbard, you attended 2 other protests before September 16th, is that right?
Yes, I did. I attended the last 3 protests after the amount of garbage. I'm glad it seemed to help with the garbage.
Mr. Everett didn't speak at either of these protests, did he?
Objection relevant.
Overruled.
Again, Ms. Hubbard, Mr. Everett didn't speak at any of the other protests you attended before the 16th?
Not that I'm aware of. This a long time ago, but I don't think so.
Is that a no, Ms. Hubbard?
As I said, no, I don't think so.
Now, to be clear, Ms. Hubbard, no one else acted violently at the protest on the 16th.
It depends what you call violently. No direct violence, but I mean, I think littering is kind of violent.
Ms. Hubbard, no one acted with physical violence at the protest on the 16th.
Not that I'm aware of.
So Everett was the only one?
I mean, there was some shoving, but he was the only one that took a big stand of violence.
Thank you. No further questions.
Any redirect?
Yes, Your Honor, briefly.
Proceed.
Ms. Hubbard, during cross, you were asked about a pending lawsuit you have against Tracy Whitney and the Demite movement. Is that why you are testifying today?
Not really. I just want whoever's accountable for all this to get held accountable. I mean, but
Objection, Your Honor. Opinion on the ultimate issue.
Sustain. Jury will disregard. Ask your next question.
Ms. Hubbard, is testifying against Tracy Whitney going to help you in your lawsuit?
I don't know for sure. I mean, maybe.
And can you tell the jury why you filed against Tracy Whitney with Wesley Everett and Britt Smithson and the Demite movement?
I'm in debt up to my eyes. I mean, I can barely get out of bed, and so I'm just trying to recover some of my losses.
Objection, Your Honor. Again, opinion on the ultimate issue.
Overruled. Answer stands. Ask your next question.
That is all I have, Your Honor. Thank you.
Okay. Any recross?
No recross, Your Honor.
All right. Thank you. State can call its next witness.
Yes, Your Honor. The state calls Meryl Grimm to the stand.
All right. Again, I understand she's been previously sworn. You may proceed.
Ms. Grimm, please state your name and spell the last for the record.
My name is Meryl Grimm. That's Grimm.
Ms. Grimm, what is your current occupation?
I've been mayor of Barryton for the past 8 years.
Let's talk about the restoration of the Altenberry statue. What was the response after the statue was refurbished?
Overall, the response was positive, but there were a few new people in town that I didn't recognize that complained.
Objection assumes not in evidence.
Overruled.
How did these people complain?
Well, they showed up at every single council meeting and they complained during the public comment period.
Did you find out who these people were?
They were members of a group called D-Mite, along with a local acquaintance of mine, Britt Smithson.
And did they ever approach you outside of these city council meetings?
Yes, they came into my office and handed me a letter.
And were you able to thoroughly read it?
Yes.
Would you recognize a copy of this letter if shown to you in court today?
Yes, I would.
Your Honor, permission to display Exhibit 6 for opposing counsel.
You may.
Permission to admit into evidence and proceed with questioning.
Any objection?
No objections, Your Honor.
Okay, proceed.
Thank you.
6 is admitted.
I am now showing you what has been previously marked as Exhibit 6. Do you recognize this?
Yes.
What is it?
This was the letter that was handed to me by Britt Smithson.
Is it a true and accurate copy of said document?
Yes.
Now, Ms. Grimm, could you please tell me whose name is at the bottom of this letter?
Tracy Whitney.
And what did you do in response to getting this letter?
Well, although the language of the letter was very demanding, I still agreed to present it at a future city council meeting.
Can you point out the line that was demanding?
Immediate compliance will avoid any unpleasant consequences for Barryton, its facilities, and its employees.
And did you hear from D-Mite again?
Unfortunately, yes. I received many threatening emails from them. Many of them were signed electronically by Smithson or Whitney.
What did you do with these emails?
Objection. May I be heard?
May be heard.
Your Honor, the mayor testified, this witness has testified that she found these emails threatening. Now, the prosecution has charged my client with 3 crimes, none of which are harassment or anything in regards to Meryl Grimm. Her opinions about these emails are irrelevant, do not make any fact in our case more likely or not, and are also substantially more prejudicial than probative.
Response?
Yes, Your Honor. This goes to the intent of the group of Tracy Whitney's involvement.
Objection is overruled. Proceed.
Thank you, Your Honor. So, would you like me to repeat the question?
Yes, thank you.
What did you do with these emails?
I had turned them over to Detective Brambro to investigate for any criminal activity.
When did these D-Mite demonstrations begin?
It was soon after they gave me their demand letter.
Did you do anything in response to these demonstrations?
I had asked the police chief to work with the protesters to help local officials go about their work.
Did you ever attend any of their protests?
Yes. Since I had known Britt Smithson, I decided to attend a protest so we could resolve our differences.
Were you able to speak with Britt?
No, the chanting was too loud and the group just wasn't interested in compromising.
So at this protest, did you see anything else?
Yes, I had noticed the crowd was chanting lines I had recognized off the D-Mite website.
Were there any phrases that stuck out to you?
Yes, the crowd yelled energetic tango, and they pumped their fists up in the air after every speaker was done, and they kept mentioning something about knocking down a house of blocks.
Now, after this protest, did you attend any others?
No, but I stayed informed about the actions of D-Mite.
And in the final protest, was the Altenberry statue damaged?
Yes, it was.
What was the cost of the damage to the statue and the plaza?
Well, the estimate is that it will cost the city $10,000 to restore the statue and bring the plaza back to its former state.
Thank you, Your Honor. No further questions.
Ross,
Yes, Your Honor.
proceed.
All right. Good morning, Mayor Grimm.
Good morning.
Now, you've been holding your position as mayor of Barryton for 8 years now, is that right?
Yes, that's correct. I'm a proud Mayor of Barryton.
Let's talk a little bit about what citizens can do if they would like to take legal action. Now, Barryton has a city council, is that correct?
Yes, that's correct.
And as mayor, you're part of this council?
Yes, of course.
And the city council holds public meetings.
Yes, we do hold public meetings.
Any citizen of Barryton can attend these public meetings.
Yes.
Well, let's talk about what members of DMIT did. They attended these public meetings.
Yes, they did attend the public meetings and they complained during the public comment period.
That's right, there's a public comment period at these meetings.
Yes, that's correct.
And any citizen of Barryton can speak during the public comment period at these meetings.
Of course, we do like to have enough time for everybody to speak though, because we want everybody to be able to voice their opinions.
Now, members of DMIT spoke during the public comment period.
Yes.
Now, any citizen of Barryton can arrange to meet with you.
Yes, any citizen of Barryton can, but like I said, we do like to space out our time so everybody can speak.
So members of DMIT arranged a meeting with you.
Yes.
Now, if a citizen really wants to raise awareness for their cause, they can organize demonstrations in public spaces.
Yes, that's correct.
So DMIT organized a few demonstrations.
Yes.
Mayor Grimm, you are personally opposed to these demonstrations, is that right?
Objection, Your Honor. Calls to speculation.
Overruled.
Well, Mayor Grimm, I'll ask again. You were personally opposed to these demonstrations, is that right?
I wouldn't say I was necessarily opposed to the demonstrations. I was just opposed to violence or destruction or any threatening or any threats towards my facility's employees.
Well, Mayor Grimm, in your own words, you called these demonstrations a monthly embarrassment to the city.
I mean, they caused some of the local businesses to not be able to get as much businesses as they would.
And so you would say that they're an embarrassment to the city?
I mean, embarrassment is a strong word. They're trying to voice their opinion, but I would say that they put a stop to some tourism that would be detrimental to some local businesses.
Well, you say that you are opposed to the violence at these protests, but let's be clear about these protests. You didn't receive any reports of violence at the first protest?
No, I did not.
You didn't receive any reports of violence at the second protest?
I didn't receive any reports of violence, no.
You didn't receive any reports of violence at the third protest either, did you?
No, I did not. But like I said, they were outside the protest. They were very threatening, and I received many emails from them that had a very threatening connotation.
Well, let's move on to the next few protests. You attended one of the protests that DMIT organized?
Yes, I did. I wanted to, since I had known Britt Smithson, I wanted to try to resolve our differences.
And this was the fourth protest organized by DMIT?
Yes, that's correct.
The one you attended was in August of 2019?
Yes.
Now at this protest, the crowd was very loud.
Yeah, there was a lot of chanting, so it was hard to be able to try to converse with Britt Smithson.
Now you saw people getting rough with each other at this protest?
Yes.
You saw Wesley Everett at this protest?
Wesley Everett was there.
You saw Wesley Everett getting rough with other people in the crowd, is that right?
Yes, among some other people that I did not recognize.
Okay, I'd like to talk about the fifth protest, which took place on September 16th. You weren't present during the actual protest?
No, I wasn't.
But you did go to the scene after the crowd had cleared out?
Yes, I saw the aftermath of the protest, along with Del Hubbard lying on the ground bleeding.
Well, when you got there, you only saw one member of DMIT in police custody.
Yes, that's correct.
And the person in police custody was Wesley Everett.
Yes.
Thank you, Your Honor. No further questions.
Any redirect?
None, Your Honor.
All right, thank you. Taking calls, next witness.
The state calls Wesley Everett to the stand.
All right, Wesley Everett has previously been sworn. You may proceed.
Thank you. Please state your name and spell your last name for the record.
My name is Wesley Everett. That's Everett.
What do you do for a living?
I work remotely as a video game designer for a firm in Alki City, but I live in Barryton.
And are you familiar with a group called Debunking This Story?
Yes, I started attending their meetings shortly after I moved to Barryton.
Are you familiar with Britt Smithson?
Yeah, he's a big deal. He's the president of the group, and we formed a friendship right from the beginning.
How did you form this friendship?
At first, we just interacted at the meetings, but it wasn't long before we started socializing outside of the group.
And are you familiar with the defendant, Tracy Whitney?
Yeah, he's an even bigger deal. We're literally here because of Tracy Whitney, and Tracy is the founder of Debunking Mystery, and Britt gave me their contact information soon after we met and started corresponding from there.
How did you correspond?
Occasionally through email, but mostly through this texting app that encrypted our messages in real time.
And did you save any of these messages?
Unfortunately not. The app wouldn't allow content to be copied or saved, and it would delete the messages soon after they were sent.
Did Tracy ever communicate with you the goal of DMITE?
The goal was the destruction of all historic statues.
How is this to happen?
We had pressured the authorities like the mayor or the city council to take down the statue.
And if that pressure didn't work?
Then violent action against the statue and those who protected it would be necessary.
Do you have any communications that show that the defendant was advocating for violent behavior?
None that I have saved. Explicit references only came up in inner circle meetings or scrubbed messages, never in anything public.
And when did the group turn their sights on the Altenberry statue?
It was, I think, April of 2019, Tracy decided we were ready.
And how did you begin?
We pressured the city council and demanded that they remove the statue.
How did city council respond to your pressures?
They rejected our demand, but that was something that Tracy had expected.
Objection, this calls for, or objection, speculation.
Sustained. Jury will
Your Honor,
disregard.
And I move to strike the inadmissible testimony.
Sustained. Jury will disregard. Proceed.
Did you attend any of the protests?
I didn't attend the first three because my job was to bail any inner circle members out of jail.
No, I thought these were peaceful protests. Why would there be any need to bail anyone out of jail?
I'm not sure what Tracy expected, but that was my job that I was given.
Now, besides the demand letter and the protests, what other methods did the DMA organization use to pressure the mayor?
We sent emails, texts, and also made phone calls to the mayor. And I covered my tracks using the methods that Tracy taught me.
My co-counsel is now showing opposing counsel what has been previously marked as Exhibit 4. Permission to proceed or to display to the witness and to proceed with questioning.
You may.
Maybe we have a minute to get the exhibit up, and we seem to be having some technical difficulties.
Sure, no problem.
Your Honor, I can show the exhibit if that's okay with opposing counsel. I have it up.
All right, proceed. Thank you.
Now, do you recognize this document?
Yes, I do. It appears to be an email chain between myself and Whitney.
And is this a true and accurate copy of that document?
Yes, it is.
Your Honor, I move to admit Exhibit 4 into evidence.
Is it 4 or 5?
I believe it's 4. I think my co-counsel scrolled down.
It's listed as Exhibit 5 is the reason I'm asking, what I'm looking at least. Is that what you meant to have up?
Yes, that is what we meant to have up.
Okay, because I don't think that's what he was responding to, so you may want to ask your foundational questions again.
Okay. Do you recognize this document?
Yes, I just got mistaken last time and mistake text for emails, but this is clearly emails now between myself and Whitney.
And is this a true and accurate copy of those emails?
Yes.
Your Honor, I move to admit Exhibit 4 into evidence.
Any objection?
No objections, Your Honor.
Exhibit 4 is admitted.
In the emails, you talk about waiting for the day when the blocks can go tumbling. What did you mean by that?
That meant bringing down the statue by any means necessary.
Now, you also used the term energetic tango in a September 6th email. What does that mean?
We had agreed privately that when the defendant spoke those words, it was the signal to use immediate force to accomplish our aims.
And how did Whitney respond to your use of the term in the message?
She chastised me for using the term and reminded me not to use it in any public email or communication to her, and also to delete any messages after I read them. She also used an exclamation point, and who even does that in an email?
My co-counsel is now showing opposing counsel what has been previously marked as Exhibit 5. Permission to proceed with the questioning.
You may.
Do you recognize this document?
Yes, this is some text between myself and Tracy Whitney.
I would like to direct your attention to a text message sent on September 15th that reads, "Ready to bring the hammer down tomorrow?" Was that from Tracy Whitney?
Objection, Your Honor, this exhibit has not been admitted into evidence yet.
Right. By previous stipulation, we're showing it, but you do go ahead and lay foundational questions for it.
Do you recognize this document?
Yes, I do. It's text between myself and Tracy Whitney.
Okay, Your Honor, I move to admit Exhibit 5 into evidence.
Any objection?
No objections, Your Honor.
Exhibit 5 is admitted.
Now I would like to direct your attention to a text message sent on September 15th that reads, "Ready to bring the hammer down tomorrow?" Was that from Tracy Whitney?
Yes, it was.
And when did the final protest take place?
September 16th, the day after this message.
And for the protest on September 16th, were you still in charge of bailing people out of jail?
No, my new job was to write speeches and hype up the crowd.
Was Whitney at this protest?
Not in person, but they were there through a broadcast on my tablet, offering words of encouragement.
And what did he say?
Lots of things that Tracy had said to me before, and they would appear on the tablet periodically, yelling things like, "We must never surrender," and "Now is the time for direct action," along with other generic quotes from the website.
Was that all they said?
No, towards the end of the protest, Tracy's face filled my entire screen with volume on full blast and yelled, "Energetic tango."
And what happened after you heard the defendant?
Feeling invigorated by what Tracy had said, I climbed up onto the statue and Britt handed me a sledgehammer.
Mr. Smithson handed you a sledgehammer?
Yes, they did.
And then what happened?
I used the sledgehammer to start hitting the statue, and that's when I accidentally struck Mr. Hubbard. I feel absolutely terrible about it, and I never meant to hurt anyone.
Now, what has happened since that day?
It came out that Hubbard got really injured. The sledgehammer just slipped out of my hands. I don't even like hammers. I wouldn't have been up there if it wasn't for Tracy Whitney. I'm so sorry, Mr. Hubbard.
Thank you, Your Honor. No further questions.
Cross-examination?
Yes, Your Honor. Good morning, Mr. Everett.
Good morning.
Now, on September 16th, 2019, when you jumped up onto that statue, your goal was to knock down the statue, wasn't it?
Yes, it was.
So when you injured Del Hubbard, that was an accident?
100% an accident. We never meant for that to happen.
So let's just make one thing clear, Mr. Everett. On September 16th, 2019, you did not intend to hurt anyone, did you?
Absolutely not. We just were trying to destroy the statue.
Let's talk a little bit more about that protest. On direct examination, you said that Tracy Whitney yelled a code phrase, didn't you?
Yes, they did. They yelled energetic tango.
Right, and Mr. Everett, you said that because of this code phrase, you jumped up onto that statue.
Yes, we had agreed privately that when Tracy said those words, that's what I would do.
Right, but Mr. Everett, in your sworn affidavit, you also say that everyone in the DMIT inner circle agreed upon the meaning of this code phrase.
Yes, we did.
And Mr. Everett, there were other inner circle members at that protest?
Yes, there were.
And you said that Tracy Whitney screamed that code phrase.
Yes, through my tablet, of course.
Yet, Mr. Everett, you were the only person hitting that statue with a sledgehammer, weren't you?
Well, someone had to give me the sledgehammer, and that was Britt.
So that's a yes, you were the only person hitting that statue with a sledgehammer?
Yes, I expected other people to start hitting it, but I don't know what was up with them.
Let's talk a little bit about why you're testifying here today. Mr. Everett, after you damaged that statue, the crowd of DMIT protesters left the scene, didn't they?
Yeah, I thought it was so weird that the crowd disappeared so quickly.
That's right, Mr. Everett, you were frustrated by that, weren't you?
Yeah, I thought it was so weird.
You didn't think that you should take all the blame for the incident.
Of course, I take responsibility for my part, but Tracy Whitney is yet to take responsibility for what they've done as well.
So, Mr. Everett, before coming to trial today, you pled guilty to 3 separate crimes.
Yes, I did.
You pled guilty to 1 count of malicious mischief in the first degree.
Yeah, but isn't that a weird name for a crime?
So that's a yes?
Yes, it is.
You pled guilty to 1 count of reckless endangerment.
Yep.
You pled guilty to 1 count of telephone harassment.
Yes, I did.
Now, your sentencing hearing for all 3 of those crimes will happen after today's trial, won't it?
Yes, it will after I give my truthful testimony.
Your sentencing hearing for all 3 of those crimes will happen after you testify against my client.
Yes, but I'm simply here to tell the truth.
Your sentencing hearing for all 3 of those crimes will happen after the jury reaches a decision on my client's guilt or innocence.
Yes, it will.
In fact, Mr. Everett, your sentencing for all 3 of those crimes depends on what you say in court today, doesn't it?
Yes, but of course I'm under oath, so I've been telling the truth the whole time, and I will continue to tell the truth.
Thank you. No further questions.
Any redirect?
None, Your Honor.
All right, thank you. Does the state have any further witnesses?
Yes, Your Honor, if you could allow us to resituate.
Yes.
And Your Honor, if you would, could you allow the raters maybe 15 seconds between each examination so we can finish up our comments?
Thank you. Appreciate you bringing that to my attention. Absolutely.
Thank you.
Your Honor, the state would like to call Detective Jaden Brandberg.
Let me just ask, are the raters ready to proceed? Just give me a thumbs up. All right, thank you. All right. Again, this witness has previously been sworn. You may proceed.
Okay, Detective, can you see and hear me all right?
Yes, I can.
Okay, please state your name and spell the last for the record.
I am Detective Jaden Brandberg. That's Brandberg.
And Detective, what is your current occupation?
I am the lead investigating officer for the Major Crimes Unit of the Barrington Municipal Police Department.
Okay, and how long have you been working in law enforcement?
It's been nearly 20 years and thousands of hours of wiretap calls.
Okay, and how did you get started?
Well, after obtaining a criminal justice degree in Jacksonville, I was hired as a police officer and I worked there for 3 years.
Could you please explain your involvement in this case?
Of course, on September 16th of 2019, I was called to the Barrington Plaza hammer assault. I arrived about a half hour after the riot had occurred.
And what did you do when you arrived at the scene?
Well, the security guards had a suspect in custody, Wesley Everett, so I just began to interview witnesses.
And who did you interview?
A reporter on the scene, Lynn Strong. I was also able to view the footage she had captured of the incident.
Okay, and what did you learn?
Well, I learned that the hammer used by Wesley Everett had been handed to him by someone else.
Objection, this is based on hearsay.
Sustained.
And Your Honor, I move to strike the inadmissible testimony.
Sustained. Jury will disregard. Proceed.
Okay, moving on. Detective, were you able to interview the victim?
I did. I went to the hospital to try and interview the victim, Del Hubbard, but he was in surgery, so I just returned to the station.
Okay, and where was Wesley Everett at this time?
He had been arrested and he was holding at the station. I attempted to speak with him, but I couldn't get much out of him.
Okay, so you had the suspect in custody. Was that the end of your investigation?
No, a local organization called Debunking Mid-Story, they held a press conference disavowing any association with Wesley Everett. I decided to look into them.
And did you ever meet Wesley Everett?
I did. I received a call from Pine County Jail, and I was told he wanted to speak with me, so I went to go talk with him.
Okay, and what did you learn from your conversation with Mr. Everett?
She claimed the entire plan was not her idea and that it was actually the founder of Debunking Mid-Story, Tracy Whitney.
Objection, hearsay.
Ons?
Your Honor, my witness is testifying as to what she heard from in the investigation with the witness, Wesley Everett.
Objection is sustained. Jury will disregard.
Okay, Detective, what did you do to investigate the claims?
I did some research into DMITE.
And what did you find?
I discovered that in 4 separate incidents, DMITE had called for the removal of statues of historically important figures.
And were these incidents similar to what happened in this case?
Yes, in each case, the statues were damaged during demonstrations, and in one case, a security guard was severely wounded.
Objection, this is based on hearsay.
Response?
Your Honor, my witness is testifying as to what she heard from her
Sustained.
investigation.
And Your
Sustained.
Honor,
Jury will disregard.
I move to strike the inadmissible testimony.
Yeah, I've already instructed the jury to disregard. Proceed.
Detective, did you find anything else?
Yes, I also found a wanted poster on the DMITE website calling for the destruction of the statue by any means necessary.
And what did you do with that information?
Well, it was enough that I was able to get a judge to sign off on a search warrant, and I obtained records of electronic communication between Wesley Everett and Tracy Whitney.
Okay, did you find anything?
I did. I found a significant amount of messages between Wesley Everett and the defendant, and I was able to detect coded language within them.
And how were you able to detect that?
I have specialized training and experience in detecting and deciphering coded messages.
And where did you receive that training?
I was recruited to join an elite unit of the Drug Enforcement Agency, and I received special training in listening to and deciphering coded language.
Okay, and how did you use that training?
Well, my primary responsibility was to listen to and document thousands of hours of wiretap calls, analyzing the conversations for hidden meaning.
Okay, how long did you work as a code breaker for the DEA?
For 6 years.
And were you able to use any of that experience in the training in the case today?
Absolutely, it proved to be invaluable in investigating the criminal conspiracy in this case.
Objection, legal conclusion. The witness just asserted that there was a criminal conspiracy.
Same, jury will disregard.
Detective, did you reach a conclusion?
Yes, I was able to analyze the defendant's communication with the members of the DMI movement and determined she was using coded language to communicate with them.
And could you give us an example of the coded language?
Of course, the use of blockhouse. Tracy Whitney's message talks about knocking down the blockhouse or invading and destroying the blockhouse. This was a direct call for violence.
And were there other examples?
Yes, he also manipulated a quote from Gandhi. He tried to hide behind Gandhi's nonviolent image while still calling for direct action.
And what was the most significant use of code?
The term energetic tangos, classic criminal coding. It's an allusion to a similar phrase used by other extremist groups, Electric Boogaloo. It is signaling that the group's second writing of history is both imminent and violent, and that is a perfect code base for action.
And did Tracy Whitney do anything else besides use coded language to conceal their message?
Yes, he took extraordinary steps to conceal his actions by using encrypted communication and self-deleting messages.
Thank you, Your Honor. No further questions.
Cross-examination?
Yes, Your Honor, but before I begin, may I ask the bailiff how much time is left for cross-examination?
Counsel, you have 7 minutes and 41 seconds remaining for cross-examination.
Good morning, Detective.
Good morning.
Detective, at the Barrington Municipal Police Department, it's standard practice to conduct thorough investigations, isn't it?
Of course, yes.
So as part of your thorough investigation of today's case, you attempted to obtain some security footage of the September 16th protest. Isn't that right?
Yes, I did try.
And you failed to obtain any security footage of that protest?
Well, none of the cameras were pointed towards the Altenberry statue, which was very inconvenient.
Detective, as part of your thorough investigation, you questioned some reporters who were at that protest, didn't you?
Lynn Strong, she was there when I arrived to the scene, so I didn't interview her.
And Detective, you also interviewed some other reporters?
Yes, but by then it was old news, so most of them just couldn't provide me with much valuable information or evidence.
That's right, Detective. You weren't able to get any useful information or footage from those reporters, were you?
I was able to view the footage Lynn Strong had captured of the incident, although it wasn't very clear because it was very blurry and the camera was bouncing up and down a lot. I was still able to view, and she did provide me with some information that I was able to use in my investigation.
But we don't have any of that footage in court today?
No, we do not. Like I said, it was very blurry and out of focus, so it didn't really hold much evidentiary value.
Thank you, Detective. As part of your thorough investigation, you also questioned some members of the public who attended DMIT meetings, didn't you?
Yes, along with other people who have been involved with some of the other incidents I looked into. Yes, I did.
No, none of those people said that they heard any mention of taking down statues with sledgehammers at those meetings, did they?
Not during those meetings. I believe all the violence and everything else occurred during DMIT Inner Circle meetings and through the encrypted communications.
All right, well, Detective, in fact, you did interview some of those DMIT Inner Circle members, didn't you?
Yes, I did.
But again, Detective, none of those people said that they heard any mention of Wesley Everett going to take down a statue with a sledgehammer, did they?
None of them were willing to admit or agree to Wesley's actions, although that doesn't mean they weren't true.
So none of them ever said that Wesley Everett was going to take down that statue with a sledgehammer?
Again, none of them were willing to talk much about it or willing to admit to any of Everett's claims, at least not with me.
Oh, Detective, let's talk a little bit about your experience. You mentioned on direct examination that you're an expert in decoding communications.
Yes, I have extensive experience.
And you received that training in your work at the DEA?
Yes.
Now, Detective, you attempted to use that experience decoding drug trafficker communications in your investigation of today's case, didn't you?
My experience has been heavily focused on drug dealers and gang members, but my training applies to all areas of code, which makes me qualified to investigate and decode the areas of code within the context of this case.
But Detective, we can agree there are no drug traffickers in today's case?
There isn't, but like I said, my training applies to all areas of code, regardless of the organization. My practices and skills do not vary between criminal organizations.
All right, now, Detective, let's talk about those code phrases you mentioned. One of them was the phrase energetic tango, wasn't it?
Yes, that's one of the phrases that I determined to be coded language for direct violence.
Right, now, Detective, based on your careful and expert analysis, it's your opinion that energetic tango is a reference to the movie Break Into Electric Boogaloo. Isn't that right?
Yes, that's what I said.
Now, you came to that conclusion because you just thought that energetic tango sounds like electric boogaloo, didn't you?
No, like I said, I have experience and training that applies to all areas of code, and it is those practices that I use to determine which phrases I consider to be coded language.
All right, well, Detective, the warrant you obtained for today's case was limited to a few select communications, wasn't it?
And that was because Tracy Whitney routinely went out of her way to use self-deleting messages and other types of encrypted communications. But even though I was only able to find 2 chains of text and emails, that was enough for me to base my conclusions, as there was a significant amount of coded language within those 2 texts.
So that's a yes to my question.
Could you repeat your question?
That warrant that you obtained for today's case was limited to a few select communications?
Yes, and like I said, there was reasons for that.
So that warrant did not include what movies Tracy Whitney may or may not have watched, did it?
I don't see how that would be relevant, but it did not include any of that.
So Detective, you can't tell us if Tracy Whitney watched Break Into Electric Boogaloo.
Objection, relevance.
Your Honor, excuse me.
Objection is overruled. I'm sorry, go ahead.
So Detective, you can't tell us whether or not Tracy Whitney watched Break Into Electric Boogaloo.
I'm not sure. You would have to ask Tracy.
So you can't tell us that?
It's not in my knowledge.
You can't tell us if Britt Smithson watched Break Into Electric Boogaloo?
I cannot, but I can't.
You can't tell us if any member of the DMED organization watched Break Into Electric Boogaloo?
I cannot tell you that. It's not in my knowledge.
Now, Detective, let's talk about where you got these code phrases. You first learned about them by interviewing Wesley Everett, didn't you?
No, I learned about these communications and code phrases within the communications. That's where I found the phrases.
Detective, we can agree that you first learned about these code phrases by interviewing Wesley Everett, can't we?
Wesley Everett.
I'm sorry, what was your objection?
Asked and answered.
Overruled.
So Detective, is it your testimony that you didn't learn about these code phrases by interviewing Wesley Everett?
Well, Wesley Everett mentioned the phrases, but it was then when I did more research into the communications where they appeared again on the DMI website, and that's when I determined that they were code.
But you initially learned about them from Wesley Everett, isn't that right?
He mentioned, when I first met with him, he mentioned the blockhouse and needing to invade or destroy the blockhouse.
Now, Mr. Everett, or excuse me, Detective, the first time you spoke with Mr. Everett, he was only babbling nonsense, wasn't he?
He was just repeating and very adamant about needing to bring down the blockhouse or invading and destroying the blockhouse.
But the next day he wanted to speak with you, didn't he?
Yes, he did. He reached out to me. He wanted to speak with me, so I went to go speak with him.
One of the first things he told you was that he wanted a plea deal.
Well, he first told me that it was not his idea and that it was Tracy Whitney's plan. And he just wanted me to hear his side of the story, but then he also did request a deal.
That's right. And after he told you those things, Detective, you were able to begin interviewing possible witnesses.
No, actually, Wesley was not the reason I began my investigation. It was the efforts from the DMI movement to try to say that they were not affiliated with Wesley Everett during their press conference And it was those lies that made me, that sparked my interest in beginning my investigation.
All right, well, Detective, you were able to analyze some texts and emails after interviewing Wesley Everett?
Yes, I did.
Those were texts and emails from very specific dates and times?
Yes.
Those were the only texts and emails that you analyzed in today's case, weren't they?
Yes, but like I said, Tracy Whitney deleted messages and used encrypted communications. So it was very hard to find more messages, but it doesn't mean that there were many, many more.
So that's a yes.
I guess so, yes.
Thank you. No further questions.
Any redirect?
Yes, but first I would like to ask how much time I have.
Counsel, you have 30 seconds remaining for your case in chief.
Great. Detective, what is the difference between investigating a drug or narcotics case versus a case like today?
Well, the crimes and scopes are different, but the skills I use for both cases are the same.
And during your investigation with Wesley Everett, did you find any evidence of direct call for violent action?
Yes, Tracy Whitney made a mistake. She didn't cover up her tracks very well on Exhibit 3, the wanted poster. She specifically quotes, "by any means necessary," a quote directly from Malcolm X, who was known to have promoted and advocated for violence.
Objection, Your Honor. The witness is referencing an exhibit that has not been admitted into evidence yet.
Overruled.
Detective, was that the end of your answer?
Yes, I was actually saying that with a direct quote from Malcolm X, who was known to promote and advocate for violence.
Thank you, Your Honor. No further questions.
Any recross?
No recross, Your Honor.
All right, thank you. Does that conclude the state's case?
Yes, Your Honor, the state rests.
All right, thank you. We will take a 5-minute recess at this time.
Yes, Your Honor.
All right, hopefully everyone's back. Defense can call its first witness.
We are ready to proceed, but before we begin, Your Honor, are all the members of the jury present? Oh, there we go.
That's a good question.
Are we ready to begin, Your Honor?
Yes, you may call your first witness.
The defense calls Tracy Whitney to the stand.
All right, and again, Tracy Whitney has previously been sworn. You may proceed.
Good morning. Please introduce yourself to the court.
Good morning. My name is Tracy Whitney, and I go by he, him pronouns.
Mr. Whitney, before we begin, let's get a few things straight. Did you tell Wesley Everett to attack the statue of Alton Berry?
No.
Did you and Everett have an agreement to attack this statue?
Well, certainly not.
Mr. Whitney, did you know that Everett was going to attack this statue?
No.
And did you see anyone else at this protest acting violently?
No. Everett was the only one.
Now, what do you do for a living, Mr. Whitney?
Well, I'm an activist for the truth. Sooner or later, the truth will get out about the people of our history, and my organization, Debunking Mysteries, or DMIT, aims to accomplish this.
What is DMIT?
Well, DMIT is an organization for the truth. There are no heroes of our history, only deeply flawed individuals, and putting any of them on literal pedestals destroys the realities of these flaws. So we aim to remove the statues representing them to debunk their false heroic portrayals.
Do you run this organization all on your own?
Oh, no. I wouldn't be able to do everything by myself. I have staff who can help DMIT chapters carry out their projects, help me do day-to-day work, but most importantly, they help me keep DMIT's core values in focus.
What are these core values?
We hold a healthy skepticism towards the myths of the past, and we embrace non-violence. DMIT advocates for the peaceful and civic removal of statues. Statues are built for oppressors, and violence is their tools of oppression. So using violence would make us no better than the oppressors we are trying to debunk.
Now, about how many chapters of your organization, DMIT, are there?
Well, with over 100 chapters, running in over 10 countries and 38 states, our movement is growing and the truth is spreading across the globe.
What's your role in each of these chapters?
I mostly occasionally monitor DMIT chapters, reminding them of our core ideas and philosophy and encouraging them. Most of the responsibility of running the chapters are on the chapter presidents.
Now I'd like to talk to you specifically about the Barryton chapter of DMIT. Who ran this chapter in the fall of 2019?
Well, that would be Britt Smithson, as he was the chapter president of the Barryton chapter. I believe he did a good job leading the chapter, but I do wish he'd stop talking about his drill bits.
What was Mr. Smithson's role as chapter president?
Well, just like all other chapter presidents, it was his duty to run the chapter and chapter meetings, organize events, and use media to communicate the philosophy of DMIT. Additionally, it is the chapter president's responsibility to make sure their chapters in ways that reflect our values.
Mr. Whitney, are you familiar with Wesley Everett?
Yes, as I saw him testifying in court today. I mainly know of him as the ex-member of DMIT who betrayed us, going against our morals and severing his connection to the truth with his violent, deplorable actions on September 16th.
Let's talk more about the events of September 16th. Were you at the rally in Barryton that day?
No, I was at my home in Ohio.
Did you watch this rally at all?
Well, most of the day of the rally, I was busy with DMIT-related duties, but I did switch to the live stream demonstration when I had the time.
Now, Mr. Whitney, we've heard a lot today about you making certain comments during this rally. Did you give any type of signal to the group?
No, I didn't give any signal. I mean, I may have said some words of encouragement here or there, but no, there's no signal.
Did you ever use the phrase energetic tango?
Energetic tango? No, I didn't.
What does this phrase mean?
Well, energetic tango is a reference to this dumb dance I performed in an early DMIT rally. I really thought it wouldn't have been a big deal when I did it, but course, now there are some DMIT members who use it as a funny little nickname for me, even though I personally find it very disrespectful.
Now, Mr. Whitney, you mentioned watching this rally through a live stream. Did you see Everett through this live stream?
I did see him over the live stream, and at first I was almost proud of his enthusiasm, but of course he then portrayed the very foundational values of DMIT and betrayed us all when that sledgehammer got into his hands.
How do Everett's actions align with DMIT philosophy?
They don't.
And after Everett attacked this statue, what did you do?
Well, I contacted Smithson immediately to set up a press conference to clear the air and to make sure the public knew that Everett acted alone at that rally. I didn't want the truth of what we stand for to be erased and to be seen as the oppressors that we are aiming to debunk.
Now, Mr. Whitney, is the Barryton chapter still part of your DMIT organization?
No. I suspended all Pine County chapter activities and I broke up the Barryton chapter.
Thank you. No further questions.
Cross-examination?
Yes, Your Honor. Mr. Whitney, you are the founder of the DMIT organization,
That's correct, I am.
and you use multiple systems to communicate with members of your organization.
That's correct.
Now, Mr. Whitney, since we're short on time, I'd like for you to respond with simple yes or no. You will have plenty of time to explain yourself and redirect. One of these is an encrypted messaging system, correct?
Objection, Your Honor.
Sorry, your objection?
I do ask that my witness be able to give a response to his ability, not just respond with a yes or no, but what he feels is the response he wants to give.
That objection is sustained.
Would you like for me to repeat the question?
Yes, please.
One of these systems for messaging is an encrypted messaging system, correct?
That's correct.
And you are the only person with access to these encrypted messages.
They are private, so yes.
And the messages sent on here are unable to be tracked.
Well, I have a perfectly reasonable reason for this. When sharing controversial ideas over the internet, monitoring by those in power will occur. So I want to take this problem off my back. So yes, they cannot be tracked.
Okay, and this back channel is mainly reserved for higher ranking officials within your organization.
Well, I suppose.
So all of the messages between influential people in your organization cannot be viewed.
Well, it's anyone who speaks over this encrypted channel.
So another way that you communicate with members is through a computer system, correct?
That's correct.
And these computers used for this type of communication no longer exist.
Well, they were decommissioned as a part of our upgrade to our technology system. So no, they don't exist anymore.
So they happened to be erased a few weeks after the Barryton incident.
Well, this Barryton incident wasn't a particularly huge deal to my organization, so I didn't see any reason to keep any communications.
And you also used a live streaming system to communicate with your members.
Well, I use the live stream program during rallies and events.
So this allows for you to turn up the volume of the speakers on both ends of the broadcast, correct?
Well, during rallies, the crowd often gets very loud, and I want to be heard over the roar of the crowd. I want my encouraging comments to be heard. So this program does allow me to turn up the volume, yes.
So you do have the ability to make your voice louder when watching any protest.
Any rally, yes.
You also communicate with members through the DMIT website.
I don't explicitly communicate with them through the website,
Well,
but my website is
well,
up there. It exchanges.
Well, it is the central. Oh, excuse me. Well, this is the central platform to receive information about your DMIT organization.
Well, yeah, it's open to the public. Anyone can see it. If they want to join, they can.
And as founder of this organization, you would know what's happening on your website.
Well, my staff do help maintain it. I'm a very busy man. I have over 100 chapters to overlook. So I'm not entirely aware all the time about the day-to-day happenings on my website.
Your Honor, permission to display Exhibit 2 for opposing counsel.
You may.
I am now showing you what has been previously marked as Exhibit 2. Are these excerpts from your website?
That's what it appears to be, yes.
Your Honor, I move to admit Exhibit 2 into evidence.
Any objection?
No objection, Your Honor.
Exhibit 2 is admitted.
Thank you. Now, Mr. Whitney, under the events and activities next to June 15, 2019, the exhibit says, DMITE Founders Rally, Columbus, Ohio. Speaker, Tracy Whitney. Energetic Tango. Is that correct?
That's correct.
And again, on July 18, 2019, in Hartford, Connecticut, it says, clear the courthouse event. Tear the blockhouses down. Dance the ET.
That's what it appears to read, yes.
Thank you. And again, on August 22nd, 2019, it says, Baby House Block Bash, Helena, Montana, Energetic Tango, listen for the signals.
That's what it reads, yes.
So on your official website, 3 out of the 5 events mention Energetic Tango or ET.
Yes, it was likely just a staff playing a prank on me or something. I don't know. Again, I find that phrase very disrespectful to anything relating to DMITs.
Thank you. So 3 out of the 5 events on your official website mention ET, regardless of who wrote it.
Yes, unfortunately so. It's very disrespectful.
So in this case, is Energetic Tango a code word?
No, of course not. It's a silly little nickname. This has been blown out of proportion.
So all of the events calling for a statue to be taken down mention Energetic Tango.
On the website, they do, yes.
Thank you, Your Honor. No further questions.
Redirect?
Yes, Your Honor. Now, Mr. Whitney, why do you use encrypted messaging channels?
Well, when sharing controversial ideas over the internet, monitoring by those in power will occur, and it's very problematic for my organization, and using an encrypted messaging channel circumvents this issue entirely.
Now, remind us, is the phrase energetic tango a code or a signal for anything?
No, it's not. This whole thing has been blown completely out of proportion. It's just a silly, disrespectful little nickname that some DMIT members will use.
Now, Mr. Whitney, does your DMIT organization ever condone violence?
No, we don't. It simply doesn't work, and using violence would make us no better than the oppressors we are aiming to debunk.
Thank you. No further questions.
Recross?
Yes, Your Honor. So, Mr. Whitney, regardless of all of the events calling for a statue to be taken down, you still mention Energetic Tango.
The website does. I don't specifically mention that.
But you are the runner of this organization.
I'm the founder and president of the organization. That's correct.
But you control what's on your website.
I don't control what's on my website all the time, no.
But you are the owner of this website.
I am the owner of the website. That's correct.
Thank you, Your Honor. No further questions.
All right. Defense can call its next witness.
The defense calls Professor Robin Hess to the stand.
Okay. This witness has previously been sworn. You may proceed.
Is opposing counsel there yet? Good morning. Could you please introduce yourself to the court?
Hello, my name is Robin Hess, and I'm a professor of social and legal studies at Fair Harbor College.
What do you do in your work as a professor?
Well, I study how a society regulates freedom of speech, specifically allowing the open exchange of ideas while simultaneously protecting itself from truly dangerous speech and thought.
Could you tell us a little bit about your educational background?
Of course. I have a Juris Doctor degree from the University of Puget Sound Law School, as well as a bachelor's degree in sociology with a minor in political science from Siskiyou Liberal Arts Institute.
Now, you mentioned that you study and teach in the field of regulation of free expression. What sort of scholarly work have you done in this area?
Well, I teach students who are interested in the field of First Amendment law and also publish peer-reviewed papers with the subject matter usually pertaining to First Amendment law and landmark cases around First Amendment law.
So what's your involvement in today's case?
Well, I was asked by the defense to review Tracy Whitney's communications in light of the First Amendment and to make sure that they are all protected under the First Amendment. And to be clear, I'm not opining on Tracy Whitney's ultimate guilt or innocence.
And have you reached an opinion about whether Tracy Whitney's communications are protected by the First Amendment?
I have.
I'll ask you about that opinion in a few minutes, but first let's explore the basis for that opinion. Now, what sort of materials did you review to prepare to testify in court today?
Well, I reviewed the exhibits I was asked to comment on, as well as prior precedent relevant to the central issues at hand in today's case.
And are these the types of materials that are reasonably relied upon by other experts in your field?
Yes, they are.
You mentioned that you studied some relevant cases to prepare to testify. What were those cases?
Well, given that the central issue in today's case is whether Tracy Whitney's communication should be considered lawful advocacy or unlawful incitement, the main two cases that I focused on were the Supreme Court cases Hess versus the United States and Noto versus the United States, with a particular emphasis on Noto. You see, in Noto, it was held that advocating for the moral necessity of actions, even violent actions, is protected under the First Amendment.
So, Professor, how do you determine whether speech is considered advocacy or incitement?
Well, since the ruling of the Supreme Court case Brandenburg versus Ohio, the Brandenburg test has been the standard in determining if speech should be considered unlawful incitement or lawful advocacy.
And how do you apply the Brandenburg test to speech?
Well, to perform the test, one must ask three questions. Firstly, did the speaker intend to cause lawless action with their words? Secondly, would the lawless action that follows this speech follow imminently? And thirdly, would it even be likely that any lawless action would follow these words in the first place? And if any of the answers to these questions are no, the speech is classified as lawful advocacy protected under the First Amendment.
Thank you, Professor. Now, I'd like to direct your attention to your work on today's case. Have you had a chance to review the text messages between Tracy Whitney and Wesley Everett?
I have.
I now ask my co-counsel to display Exhibit 5. Professor, could you read aloud that first text by Tracy Whitney?
Yes, it says, quote, "Ready to bring the hammer down tomorrow."
Professor, is there any precedent relevant to this text message?
Yes, there is. Specifically, it would be that Hess case that I mentioned earlier. You see, in Hess, a protester demanded that other protesters should illegally take and block a street later. The court held that this speech was protected under the First Amendment as that last word later set the action in the future. Furthermore, it was understood in court that later meant later that day. And even then, that wasn't imminent enough for that speech to lose the protections of the First Amendment.
And Professor, could you apply the Brandenburg test to this text message?
Of course, well, if we go off of what was held in Hess, the word tomorrow sets that action far enough in the future that it would fail the Brandenburg test on the grounds of imminence, and therefore is classified as lawful advocacy.
Thank you. My co-counsel may now take down Exhibit 5. Professor, we've heard mention of a wanted poster in court today. Have you had a chance to review that wanted poster?
I have.
I now ask my co-counsel to display Exhibit 3. Professor, what are we looking at here?
We're looking at a wanted poster that was posted on the DMITE website.
Is this a fair and accurate copy of that wanted poster?
Yes.
The defense moves to offer Exhibit 3 into evidence.
Any objection?
None, Your Honor.
Exhibit 3 is admitted.
Now, Professor, could you read aloud the content of this wanted poster?
Of course, it says, quote, "Wanted. Altenbury statue taken down, Barryton, Washington, by any means necessary. DMITE members, do your duty. E.T."
Could you apply the Brandenburg test to this wanted poster?
Of course. The Brandenburg test, this poster fails the Brandenburg test on the grounds of intent, on the grounds of imminence, as no solid timeline has been given as to when the proposed action should take place.
Professor, can you apply any relevant precedent and compare it to this wanted poster?
Of course, you see, when I was reviewing this evidence and I came upon this poster, it reminded me of a poster from a case in the 1990s with some anti-abortion radicals who were also spreading around wanted posters. You see, these wanted posters contain personal details of abortion providers that they wanted shut down in their states. This personal information ended up leading to some of these abortion providers being sadly injured or even killed in some cases. And the court found that these posters constituted a true threat and were not protected by the First Amendment.
Now, Professor, how did you go about comparing the wanted posters in that case that you just mentioned with the wanted poster in today's case?
While on a surface level, these two posters may seem similar, there are a few key differences that set the two apart.
What are those differences, Professor?
Well, the main difference is the level of specificity. You see, in the case of the 1990s, the posters contained intimate personal details such as full names, addresses, and photographs of private citizens. Meanwhile, the poster today simply lists a general location, Barryton, Washington, of a publicly known statue.
Thank you. My co-counsel may now take down Exhibit 3. Professor, have you had a chance to review all of the writings on the DMIT website?
I have.
Have you reviewed all of the text messages between Tracy Whitney and Wesley Everett?
I have.
Have you reviewed all of the emails between those two?
I have.
And have you reviewed all of these communications in light of relevant precedent?
Yes, I have.
Have you applied the Brandenburg test to all of these communications?
I have.
And Professor, have any of these communications met all three requirements of the Brandenburg test?
No, none of them have, classifying all of this as lawful advocacy protected under the First Amendment.
Thank you. No further questions.
Cross?
Yes, Your Honor. Mr. Hess, you're here today to talk about your analysis of Tracy Whitney's communications with the DMITE members, correct?
That's correct.
You looked at three things:
Yes.
the text messages in Exhibit 5, email communications in Exhibit 4, and the DMITE website.
Yes, and I also looked at the letter that was sent to the mayor. But yes, those three things I did look at.
But you were asked not to comment on the statements made by the defendant on September 16th.
That's correct. I wasn't asked to comment on the alleged statements that the defendant made on the 16th.
So you did not analyze these statements.
No, I didn't analyze the alleged statements.
And you also did not look at any further text message communications between Tracy Whitney and the DMITE members outside of Exhibit 5.
No, I did not.
And you also did not analyze any of the recordings or transcript of DMITE meetings and video conferences.
No, I didn't.
But even based on what you did analyze, you still found some issues.
Yes.
In fact, you yourself say that your own expert opinion in this case is not as strong when you consider Exhibit 3.
That's correct. However, upon further examination, you can see that these two posters are separate.
Yes, we will speak of that in a short moment. Now, Exhibit 3 is a wanted poster that's included in the DMITE website.
That's correct.
And you found significant similarities between this poster and another in which the case was subjected to prosecution.
Yes, however, there are also a few key differences that separate the two.
Yes. When you analyze this poster, you found that there were two main differences that made this case distinguishable from the other one,
Yes.
being lack of location
Yes.
and expression of what the statue is wanted for, correct?
That's correct.
Your Honor, showing opposing counsel what has been previously marked as Exhibit 3.
Okay.
Mr. Hess, I am now showing you what has been previously marked as Exhibit 3. Is this a true and accurate copy of the DMITE poster you analyzed?
Yes.
Your Honor, permission to admit Exhibit 3 into evidence and to publish to the jury.
I believe Exhibit 3 was previously admitted.
Thank you. Now,
You may publish.
Thank you. Now, Mr. Hess, Barryton, Washington is a location.
Yes, a general location. Yes.
But it is a location that you could point to on a map.
Sure, yeah.
And looking over the DMITE website as part of your analysis, you have read that the goal of DMITE is to take down all statues.
That's correct.
So this group wants the statue of Alton Berry to be taken down by any means necessary.
Yeah, that's correct.
Thank you, Your Honor. No further questions.
Redirect?
Yes, but before I begin, may I ask the bailiff how much time remains for direct examination?
Council, you have 10 minutes and 4 seconds remaining.
Professor, why do you say that that wanted poster lacks a specific location?
Well, again, it's the specificity of location. You see, again, in the case in the 1990s, these were specific addresses that pointed to a single location. Meanwhile, the location Barryton, Washington, that's an entire city. It's a massive area. It's not as specific, and therefore the two are distinguished from each other.
Professor, have you heard about those alleged statements made by the defendant in court today?
I have heard about those alleged statements made in court today.
Professor, has your opinion changed at all upon hearing those statements?
No, it hasn't.
Thank you. No further questions.
Hey, recross.
Yes, Your Honor. Mr. Hess, you would agree that any DMITE member can go to Barryton and know where the statue is located if it is their intent to take it down.
Objection. This question calls for speculation.
Overruled.
Your Honor,
Overruled.
thank you. Would you like for me to repeat the question?
Sure.
So you can agree that any DMITE member would know where the statue of Alton Berry lies within Barryton.
I can't agree on that. As I've heard in court today, DMITE is a worldwide organization. I wouldn't expect someone to know in, say, Asia, where a statue specifically in Washington is.
Yes, but for this specific chapter of Alton Berry, you would agree that DMITE members know where the statue is located.
Again, I can't say because I don't know them on a personal level. I can't say that.
Thank you, Your Honor. No further questions.
All right. Defense can call its next witness.
The defense calls A. Lindstrong to the stand.
All right. Again, this witness has previously been sworn. You may proceed.
Before I begin, may I ask the bailiff how much time do we have left for direct examination?
You have 9 minutes and 22 seconds remaining.
Thank you. And is the opposing counsel ready? Who will be crossing this witness?
I have not seen a response. There we go. All right. Proceed.
Please introduce yourself to the court.
Hello, my name is Aylin Strong. As you might have heard from Detective Jaden Brandberg, some people just call me Lynn Strong, but please include the A. It comes from my mother.
Ms. Strong, what do you do for a living?
I'm a journalist and a reporter for the Barryton Standard, which is Barryton's own very local newspaper. I think of it as a stepping stone, but we'll see.
Are you familiar with the statue of Alton Berry?
Oh, yes, I would see that statue every time I would go into City Hall, which happens to be my main beat as a reporter.
Are you familiar with the DMIT organization?
Yes, I am, and I am familiar with their quest to have City Council take down that Alton Berry statue over 2019.
As someone who covers City Hall regularly, how have you become familiar with the organization's campaign against the statue?
Well, I did a series of articles on their protests to have the statue taken down, and I did eventually cover the statue's violent removal.
Was DMIT's campaign against the statue successful?
Ultimately, it was not. The City Council did reject their proposal.
Were you present at the council meeting in September when their proposal was rejected?
Yes, I tend to be at most of those meetings, though this was one of the more interesting ones.
During the council meeting where the council voted, what did you see DMIT members do?
Well, after they had learned of the news, they got up and peacefully walked out.
Let's talk about some of your encounters with the DMIT group. Are you familiar with the series of rallies that they organized?
Yes, I reported on all of them. Always a good story.
Do you know who Wesley Everett is?
Yes, I had seen him with the DMIT group, and I know that he was the one who eventually knocked down the Alton Berry statue.
Ms. Strong, do you recall seeing Wesley Everett at any of the first 3 rallies?
The first 3, no.
Was there any violence at the first 3 rallies?
Not at the first 3.
Now, I'd like to talk about the last rally that DMIT organized. Did you attend this rally?
Yes, I did. That was the one where, unfortunately, Del Hubbard got injured.
Ms. Strong, as a reporter, what is your job when you attend events such as the rally in September?
Oh, well, as a reporter, I've been trained to observe. At any major event like this, I will be taking notes, but also paying attention to what seems most important so that I can recall major facts later and write a cohesive article.
I want to focus your attention now on the moments shortly before Everett got on the statue. At that point, what were the speakers talking about?
They were discussing future plans, such as appealing the council's decision to an appellate court and also holding more regular rallies and meetings.
Did any of these speakers call for violence?
No, there was no mention of violence or that anyone in the crowd take down the statue.
All right, Ms. Strong, let's walk through what happened next. What did you see Everett do moments before he got on the statue?
Well, moments before, I saw him shove something into Smithson's hands, and because he had been nearby, and then I saw him bend over, and then he was up on the statue with a sledgehammer.
When Everett got on the statue, what reaction did you see from Smithson?
Well, Smithson was standing there, but I could tell that he was shaking. He seemed shocked.
What did
Objection, Your Honor, speculation.
Your Honor, may I respond?
You may.
The witness is testifying to her rationally based perception of this event and Smithson's actions after Everett got on the statue. Therefore, she's not speculating as to Smithson's state of mind.
Objection is overruled.
When Everett got on the what did Everett do on the statue?
Well, with the sledgehammer, he started whacking the statue 3 times until eventually everything fell down on Del Hubbard.
Did you see how Everett got this sledgehammer?
No, I did not.
Ms. Strong, how many people did you see holding a sledgehammer?
Only one person.
And who is that person?
Wesley Everett.
How many people damaged the statue?
Just one person.
And who was that person?
Wesley Everett.
Thank you, Your Honor. No further questions.
Cross-examination?
Yes, Your Honor. First, I would like to ask how much time is left on cross-examination.
Counsel, you have 10 minutes and 1 second remaining for cross-examination.
Okay, thank you. Ms. Strong, at the beginning of your reports, Smithson was a constant source of information. Is this correct?
Yes, it was nice, because I like having sources for where I get my facts.
And this changed, didn't it?
One time, it did change, and he did become more closed off.
It changed because after you asked Britt to interview Tracy Whitney, he stopped talking to you?
Yes, he would still provide me with some materials, but like I said, he did become more closed off.
Okay. Now, I'd like to talk to you about the final protest on September 16th. You watched the DMI broadcast at this event?
Yes, when Smithson and I had been on better terms, he provided me with an access code to the live stream.
And while you were able to watch this broadcast, you were not able to record any of it?
No, there was some sort of blocking device.
And during the broadcast, you noticed Tracy Whitney, their image flash over the screen a couple of times, correct?
Yes, it reminded me of the computer-generated images that I'd seen on his website, but you're right, I did see his image flash a couple of times.
In fact, you noticed this image again about 30 seconds before Wesley Everett jumped on the statue, right?
Yes, that is true.
You noticed Whitney's image appear and shout something indistinct?
Yes, it was a very loud protest, and it was a very quick flash, similar previous to the other times, but you're correct.
And right after that, you saw Everett shove something into Smithson's hands and jump onto the statue?
Yes, like you said, it was about half a minute, but that is true.
So they were standing right next to each other right before Wesley Everett jumped on the statue?
Who exactly are you referring to?
Britt Smithson and Wesley Everett, they were standing next to each other? Okay.
Yes, and of course, like I said, Smithson had seemed shocked.
And you were not able to speak or see Smithson after the events until a couple of days later when DMAT held a press conference, correct?
Well, yes, everyone in the crowd took off like a shot once Everett started attacking the statue. I got a little scared.
And at the DMAT conference, were they denied any contact or involvement with Mr. Everett? Is this right?
Yes, I cannot speak to whether that is true or not.
The same Everett who had been testifying who you testified had been a speaker at the last protest, right?
Yes.
And the same Everett who you saw talking and standing right next to Smithson pretty much the whole protest, correct?
They both got up to speak at different times. I cannot say what their relationship is.
Thank you, Your Honor. No further questions.
Ross? I'm sorry, we're back to direct. Sorry, redirect. Didn't you redirect?
No redirect, Your Honor.
All right, thank you. Defense calls next witness.
The defense calls Britt Smithson to the stand. Good afternoon. Please introduce yourself to the court.
Hi, I'm Britt Smithson.
Mr. Smithson, what do you do for a living?
Well, I'm the owner of Smithson Construction, but on the side, I was the chapter head of the Barryton chapter of DMIT.
What is DMIT?
DMIT is an organization headed by Tracy Whitney who aims to remove statues through civic action.
How did you get involved in DMIT?
Started back when I created the Barryton Alt Historical Society, just me and some buddies chatting about history. But eventually our conversation started to grow stale, and we associated with the higher brand, which was DMIT, to attract some new members and new ideas.
How involved was Mr. Tracy Whitney in your chapter of DMIT?
Whitney wasn't super involved. Whitney would give us some inspiration and advice, but I managed the Barryton chapter myself.
To your knowledge, has Mr. Whitney ever been to Barryton?
No, not that I know of.
And Mr. Smithson, are you familiar with Wesley Everett?
Yes, I am.
How do you know Everett?
Everett would come to some of the public DMIT meetings.
We've heard a lot today, Mr. Smithson, about the phrase energetic tango. I'd like to talk to you a little more about that. Are you familiar with this phrase?
Yes, I am.
What does it mean?
So a while back, the guys and I found this video of a protest in New Mexico where you could see Whitney doing some very silly dance. We dubbed that dance the energetic tango, and it's a nickname we use for Whitney now. He hates it.
Does this phrase have any other meaning?
No.
Now let's talk about the events of September 16th. Were you at the rally that day?
I was.
Was Mr. Whitney at this rally?
No, but Whitney could see what was going on through some kind of live stream, and I think they could make comments and such.
Did Mr. Whitney talk through this live stream at all?
Yes, like I said, I think Whitney was saying some things, but again, I couldn't really hear what was said.
Who were the main speakers at this rally?
Well, I was, some other important members of the Barryton chapter, and Wesley Everett also spoke twice.
Did you know Everett was going to speak twice?
I had no idea Everett was going to speak at all.
What happened the second time Everett spoke?
That was when Everett jumped up on the statue holding my sledgehammer and started attacking the statue. Now, I can tell you that's not what that tool is used for.
Do you know how Everett got a hold of your sledgehammer?
I have no idea. Last I checked, it was in the back of my truck. I'd just come over from the construction site.
What did Mr. Whitney do once he learned of Everett's attack?
The first thing Whitney did was have me call a press conference to disavow Everett's actions and not tarnish DMIT's reputation, as that's not the kind of things we advocate for.
Now, Mr. Smithson, before that final rally, did you know what Everett was going to do?
No, of course not.
Did you instruct Everett to attack the statue?
No,
Did you agree to a plan with Everett to attack this statue?
absolutely not.
To your knowledge, Mr. Smithson, did Mr. Whitney instruct Everett to attack this statue?
No,
To your knowledge, did Mr. Whitney agree to a plan with Everett to attack this statue?
no,
And Mr. Smithson, did anyone else at this protest act violently?
not that I know of, just Everett.
Thank you. No further questions.
Cross-examination?
Yes, Your Honor, thank you. Mr. Smithson, you are the president of the Berrytown chapter of Debunking Mystery,
Yes,
and Tracy Whitney is the founder of that organization.
that's right.
And you researched debunking mystery before starting a chapter?
Yeah, I did. Of course, I did a little bit of research before associating with a higher brand.
Right, and you thought that Whitney's ideas on organization and plans for action were just the thing your group needed.
Yeah, some new ideas. Yeah.
But you didn't agree with all of Tracy's philosophy.
No, I thought Whitney had some interesting ideas, but I didn't agree with all of them.
Right, you didn't agree that all statues should be removed.
No, I didn't.
And you did think that some of Demite's ideas about direct action seemed too aggressive.
Yes, those were some of the ideas I disagreed with.
But regardless, you shared the materials and handouts from Demite during the meetings.
That's right.
In fact, you stated some of the protest techniques could only lead to violence.
Yes.
But despite your concerns, you became a formal Demite chapter.
Yeah.
And Wesley Everett was a member of the local Demite chapter?
Yeah, Everett would come to the public meetings.
And he participated in video conferences with Tracy Whitney and the Demite staff.
Yeah, I think Everett was on those calls sometimes.
Yeah, but in order to participate in those discussions, you needed to receive an invitation link from you.
That's right.
But you try to keep these numbers small, right, for these meetings?
Yeah, but Everett wanted to be a part of it, so I let him in.
But the meetings were small because Tracy only wanted trustworthy people?
Yes, that's what Whitney wanted.
Tracy didn't want to disclose tactical decisions to opponents.
No.
Right. And now I'd like to talk to you about the protest on September 16th. At that protest, you handed your tablet to Wesley Everett so they could live stream.
Yes, that's right.
And while you were speaking, you heard Tracy Whitney's voice over the tablet.
Yeah, I could hear Whitney's voice pretty much the whole rally.
Okay, and after you heard Whitney, you say Everett shoved the tablet into your arms.
Well, it wasn't right after I heard Whitney speak.
So when was it?
I was giving a speech. I was just talking about some announcements. And while I was up there, I heard Whitney say something. And it wasn't for a while until after I was getting down off of the pedestal to go back into the crowd that Everett actually got up on the statue.
Right. So you had heard Whitney and then Everett shoved the tablet into your arms.
Yeah, but not right after.
Okay, and then Wesley Everett proceeded to jump onto the base of the statue?
Right, with my sledgehammer.
Yeah, your sledgehammer. That is all, Your Honor. Thank you.
Any redirect?
Yes, Your Honor. Mr. Smithson, who is the founder of DMIT?
Whitney is.
Who's in charge of the Barryton chapter of DMIT?
Me.
Mr. Smithson, why did Everett attend private DMIT meetings?
You mean the video conferences?
Yes.
Yeah, Everett just wanted to be involved, and I'm a nice guy. I wasn't going to say no to that.
Now, at the protest on September 16th, did you ever hear Mr. Whitney use a signal?
I couldn't hear what Whitney said, but no, there was no signal.
To your knowledge, does Mr. Whitney have a signal he uses at rallies?
No, if there was a signal, I would know.
And Mr. Smithson, does the DMIT organization ever condone violence?
Never.
Thank you. No further questions.
Any recross? Did council freeze up? I was asking if there
None,
was
Your
any.
Honor.
Nope.
Yeah, they had some connection issues. No recross.
No recross. Okay, thank you. Does the defense have any further witnesses?
No, Your Honor. The defense rests.
All right. Are we ready to proceed to closing arguments?
Yes, but before we begin, Your Honor, we ask for a 5-minute recess.
Okay, time-wise, I'm not sure. Well, let's keep it a little bit shorter than that. We'll take a few minutes. So we'll take a very short recess.
Yes, Your Honor.
All right, are we ready to proceed with closing arguments?
Yes, Your Honor. Yes, Your
Yes,
Honor.
Your Honor.
All right, you may proceed.
Thank you, Your Honor. May it please the court, counsel, members of the jury. Tracy Whitney was a chess master and Wesley Everett was her pawn. The defendant positioned Wesley Everett to illegally remove the statue of Alton Berry. In the process, Wesley Everett committed the crimes of malicious mischief first degree and assault second degree. He did this by attacking the statue of Alton Berry with a sledgehammer in an effort to destroy it by using any means necessary. By doing so, Del Hubbard was dealt with a devastating blow, resulting in permanent injuries. These actions all occurred in Barrington, Washington, and are essentially undisputed. The real question here is whether Wesley Everett acted alone, or as the state contends, as a pawn of the defendant Tracy Whitney, the founder of D-Mite. The state has charged the defendant with 3 crimes relating to the events of September 16, 2019, malicious mischief first degree, assault second degree, and criminal conspiracy. Instruction 9 tells us that the defendant can be held legally responsible for the conduct of Wesley Everett. This is true even if the defendant was not present at the September 16th protest. A person can be held responsible as an accomplice if he or she solicits, commands, encourages, or requests another person to commit the crime, or aids or agrees to aid another person in the committing or planning of a crime. Here, the defendant planned and was in fact the mastermind behind the illegal removal of the statue. The defendant encouraged Wesley Everett to use whatever means necessary to bring the hammer down. She hosted organizational meetings and sent text messages to solicit action by members of D-Mite, including Mr. Everett. Her contributions to the events of September 16th included not only promoting the attack on the statue, but also the devastating injury to Del Hubbard. The fact that the defendant anticipated and encouraged possible injury to city workers is revealed in Exhibit 4, where the defendant approved the use of violence against others in the protest. These actions by the defendant amounted to solicitation and encouragement of Wesley Everett. She also aided Everett in the planning of the crime, establishing the date and code phrase for action, energetic tango, the signal to begin the attack. Because of this, it is clear that Tracy Whitney was acting as an accomplice and is criminally liable for the conduct of Wesley Everett on September 16, 2019. Next, let's turn to the charges of criminal conspiracy. This is a separate crime from the accomplice liability, and you can convict the defendant of conspiracy as well as accomplice liability. According to Instruction 8, the state can establish criminal conspiracy by proving the following. First, the conspiracy can relate to either the malicious mischief or the assault. The state acknowledges that the strongest case for criminal conspiracy relates to the destruction of the statue. As discussed, the defendant and Everett agreed on their ultimate goal of forceful removal of the statue. The evidence presented at trials demonstrate many ways in which this agreement was made and made clear. The state also submits that there is sufficient evidence to prove conspiracy based on the assault. And although Del Hubbard was not identified as the specific victim, the law only requires that the conspirators, the defendant, and Everett reached a general agreement to use violence on anyone trying to stop them. Second, not only did the defendant intend for the statue to be removed, she commanded it when she shouted energetic tango to the protesters over her tablet. The defendant's entire focus was on the removal of the statue. He intended for this plan to be carried out. Lastly, in this case, Wesley Everett took many substantial steps to carry out this agreement when he went to the protest, secured a sledgehammer, climbed up onto the base of the statue, and started to swing. Thus, the state has also proven the 3 elements of criminal conspiracy beyond a reasonable doubt. Ladies and gentlemen, the defendant wanted the statue of Alton Berry removed. First, she found a young man new to the area that she could easily manipulate. She then created and published a wanted poster where she asked that the statue be torn down by any means necessary. Wesley Everett, caught up in the thrill and the strategy of the defendant's game, simply answered the call. There is no question that the defendant was clever. He took extensive steps to try and hide his involvement in his own organization. He used encrypted messages and self-deleting texts when communicating with Mr. Everett. Furthermore, he did not attend any of the rallies personally, instead choosing to participate electronically to cheer and spur on her pawns. Tracy Whitney set up all of her game pieces and was ready for checkmate. But what he did not anticipate was that Wesley Everett would eventually do the right thing, take responsibility of himself, and reveal the defendant's game. Based on all of the evidence, the state asks that you find the defendant guilty on all accounts. Thank you.
Thank you. We'll now hear from the defense.
Yes, Your Honor. Just a moment ago, Ms. Rojas of the prosecution tried to tell you that Tracy Whitney is responsible for the actions of Wesley Everett. She tried to tell you that even though Wesley Everett picked up the hammer, Wesley Everett swung the hammer, and Wesley Everett decided to do both of those things, that my client is guilty because he had a partnership with Wesley Everett and because he conspired with Wesley Everett. Ms. Rojas talked about chess pieces and games, but keep in mind there was only one player, Wesley Everett. It was a partnership of one, and it was a conspiracy of one. And today the prosecution had a burden, the burden of proof. Under jury instructions 6, 7, 8, and 9, that burden was to prove that Tracy Whitney was an accomplice to Wesley Everett when Everett damaged the statue and injured Del Hubbard, and that Tracy Whitney conspired with Wesley Everett to commit those things. The prosecution had to prove that beyond a reasonable doubt, and they have failed to do so. First, there was no assault. There was no assault on September 16th, 2019, because Wesley Everett testified today that he did not intend to hurt anyone. Now, under jury instruction number 6, intent is an element of assault in the second degree. It is an intent, or is an element not proven. It is an element that prosecution's own witness has explicitly denied. There was no assault. Second, the prosecution had to prove that my client is guilty of malicious mischief in the first degree. They had to prove beyond a reasonable doubt under jury instructions 7 and 9 that Tracy Whitney caused the damage to the Yalton Berry statue by acting as an accomplice to Wesley Everett. Now, the prosecution has argued that as part of some partnership, Tracy Whitney yelled a DMIT code phrase, causing Wesley Everett to act violently. But if that was a common DMIT code phrase, if everyone in the inner circle knew what it meant, and if everyone at the protest heard it, then why was Wesley Everett the only one standing on that statue? Why was Wesley Everett the only one hitting that statue with a sledgehammer? Why was Wesley Everett the only one who injured Del Hubbard? Ladies and gentlemen, the answer is that Wesley Everett went rogue. It was a partnership of one. Now, finally, the prosecution had to prove beyond a reasonable doubt that Tracy Whitney is guilty of criminal conspiracy. They had to prove that he entered an agreement with Wesley Everett to commit unlawful action. And they had Mr. Everett testify to that today. He told you that Tracy Whitney instructed him to injure Del Hubbard and damage the statue, that they made this agreement over texts and emails, that the whole thing was Whitney's plan. Ms. Rojas said, there's your criminal conspiracy staring you right in the face. But remember, ladies and gentlemen, the only person in today's trial who is looking to secure a plea deal is Wesley Everett. Now, wasn't it interesting how many times Mr. Everett felt the need to tell you that he was telling the truth? And let's just be clear, Mr. Everett didn't step forward. He got caught. He got arrested. Now, under jury instruction number 5, you are instructed to carefully examine Mr. Everett's testimony in light of other evidence. You are instructed to only act upon that testimony with great caution. You are instructed to not find my client guilty based on that testimony alone. The problem is, the prosecution's entire case relies only on Wesley Everett. You heard on cross-examination today how Detective Jaden Brandberg failed to gather any video evidence of the protest. She failed to gather evidence from reporters at the scene of the protest. She failed to gather evidence from members of the public. She failed to gather evidence from members of DMIT themselves. Ladies and gentlemen, Detective Jaden Brandberg's entire investigation relies only on her interviews with Wesley Everett. Those code phrases she told you about, those were fed to her by Wesley Everett. The texts and emails, Those were from very specific dates and times that Wesley Everett told her. Those were the only texts and emails that she analyzed in today's case. And even then, those communications are protected speech. Today, we took on an affirmative defense. We had the burden to prove by a preponderance that Tracy Whitney's speech is protected. Keep in mind, that burden is not as high as the prosecution's. We only had to prove that it is more likely than not that Tracy Whitney's communications failed to meet at least one of the three elements of the Brandenburg test, that they lacked intent, imminence, or likelihood. Professor Robin has testified to that today. He told you that all of those communications are protected speech. We have met our burden. It was a conspiracy of one. But I'll remind you, the prosecution also had a burden. That burden was to prove beyond a reasonable doubt that Tracy Whitney is guilty of assault in the second degree, malicious mischief in the first degree, and criminal conspiracy. And I will also remind you that the prosecution has failed to meet this burden because the fact that Wesley Everett lacked a purposeful intent to injure creates a reasonable doubt for the charge of assault. The fact that Wesley Everett went rogue creates a reasonable doubt for the charge of malicious mischief. The fact that the prosecution's entire case relies only on Wesley Everett creates a reasonable doubt for the charge of criminal conspiracy. Remember, there was only one player in this game, Wesley Everett. It was a partnership of one, and it was a conspiracy of one. Therefore, we ask that you find the defendant not guilty on all three charges. Thank you.
Rebuttal from the state?
Yes, Your Honor. Members of the jury, allow me to introduce you to the world of Tracy Whitney, full of self-deleting messages and communications from computers that were decommissioned and erased, and encrypted video conferences. That these claims counter the defense's claim that Tracy Whitney was not behind this conspiracy. Britt Smithson testified on cross-examination that those conferences were kept confidential as to not disclose their tactical decisions to their opponents. When we say that Tracy Whitney was the chess master, we mean that she treated the statue as a chessboard and she treated Mr. Everett as a sacrificial pawn. Much of the defense's case today was focused on the actions of Wesley Everett. His committed crimes of malicious mischief first degree and assault second degree. However, Mr. Everett already declared himself guilty and took full responsibility of his actions. Yet this does not give permission for DMITE to act outside of the law. We know that the defendant was acting as an accomplice because he encouraged Mr. Everett to bring the hammer down just one day before the final protest. We know the defendant was a conspirator because he had an agreement with Mr. Everett regarding the code phrase energetic tango and intended for the destruction to occur. We know that the defendant thought of this as a game, one that she has already won before and intends to win again, but it is outside of the law, and now you will prove to be her ultimate match. Because of this, the state urges you to return a verdict of guilty on all accounts. Thank you.
Thank you. Thank you all for your presentations. We may need to take a little short break before